This is a judgment in respect of an application brought by the Independent Candidate Association for direct access. The applicant, which is a registered non-profit company that represents and promotes the interest of independent candidates in the electoral system, seeks a declarator that Item 1 of Schedule 1A to the Electoral Act, the impugned schedule, is inconsistent with Sections 1C, 32A, 91, 19.2, 19.3, and 46.1D of the Constitution, to the extent that the impugned schedule provides for 200 seats in the National Assembly to be filled by independent candidates and candidates from regional lists of political parties called regional seats, and 200 seats to be filled by candidates from national lists of political parties called compensatory seats. The applicant contends that Parliament acted unconstitutionally by splitting the seats in the National Assembly into 200-200 split. This challenge stems from Parliament's passing of the Electoral Amendment Act, which, amongst others, amended Item 1 of the impugned schedule to allow for independent candidates to contest for seats in the National Assembly. The primary remedy sought by the applicant is a combination of a striking down and reading in, which will result in the word half in Item 1A of the impugned schedule being changed with immediate effect to 350, and similarly the word half in Item 1B of the impugned schedule being changed to 50. The reading in will have, if successful, will have the effect of amending Item 1 of the impugned schedule to apply to the 2024 elections. In the alternative, the applicant seeks a suspension of the declaration of invalidity of the impugned schedule for a period of 36 months to allow Parliament to address the unconstitutionality and an interim reading in Item 1 of the impugned schedule in the manner set out in this paragraph. The application is opposed by the Speaker of the National Assembly, the Chairperson of the National Council of Provinces, and the Minister of Home Affairs. The President of the Republic filed a notice of intention to oppose the application jointly with the Minister, but did not file an answering affidavit. The Independent Electoral Commission abides the decision of the court and has provided an explanatory affidavit. The Constitution itself does not specify the national and provincial election system. Instead, it outlines the requirements that the electoral system should comply with. These requirements include the need for the system to be based on a national common voters roll, provide for a minimum voting age of 18 years, and result in general in proportional representation. The Constitution caps the number of seats available for contestation in the National Assembly at 400, and in turn, Sections 46.2 and 105.2 prescribe that national legislation must provide a formula for determining the number of members in the National and Provincial Assembly. Pursuant to these provisions, Parliament passed the Electoral Act, which regulates elections of the National Assembly and the provincial legislatures. From 1994 to 2019, the election of representatives in the National Assembly was based on a two-tier compensatory system, which filled the 400 seats in the National Assembly as follows. A, 200 seats were filled from regional lists submitted by political parties, and B, 200 were compensatory seats based on the national lists of political parties. During this period, only political parties registered with the Electoral Commission could contest elections. This meant that an adult citizen was not allowed to contest an election as an individual. Shortly before the 2019 general elections, the New Nation Movement, NPC, and its associates launched an entered application for leave to appeal directly to this court against a judgment of the Western Cape Division of the High Court, Cape Town. The High Court had dismissed an application to declare certain provisions of the Electoral Act unconstitutional insofar as they did not allow independent candidates to stand for elections. We heard the matter, and on 11 June 2020, this court in New Nation Movement NPC versus President of the Republic of South Africa held that the Electoral Act was inconsistent with the Constitution as it made no provision for independent candidates to contest elections for the National Assembly and provincial legislatures. The operation of the Declaration of Unconstitutionality was suspended for 24 months to afford Parliament an opportunity to remedy the defect giving rise to the unconstitutionality. The Electoral Amendment Act came into operation on 17 April 2023. It, amongst others, introduced a 200-200 split amongst independent candidates, regional political parties, and political parties at national level. The applicant was not happy with the split and felt that the regional level should have been allocated more seats than the compensatory level. This is what caused the applicant to approach this court and launch an application for direct access and to challenge the provisions of the impugned schedule. In its view, 350 seats should be reserved for the regional tier, whilst 50 should be for the national level. The minister filed an affidavit in which he explained that after the New Nation judgment, he commissioned a panel of experts called the Ministerial Advisory Committee to produce technical proposals in response to the judgment. The MEC had to develop policy options on the electoral system that would cure the defects in the Electoral Act. After investigation and deliberation on different policy options, the minister preferred the policy option the MEC termed the minimalist approach. He instructed 4 independent advocates with expertise in constitutional and electoral law to prepare a draft amendment bill in line with that policy. The bill was published in the Government Gazette on 31 December 2021 as the Electoral Amendment Bill. On 13 April 2023, after public participation processes, the President signed the Electoral Amendment Bill, and it was published in the Government Gazette on 17 April 2023, resulting in the Electoral Amendment Act, which contained the impugned schedule. In terms of this act, the allocation of seats in the National Assembly is still divided into equal halves. The first 200 seats referred to as the regional seats, and the other 200 as compensatory seats. Independent candidates and political parties can both contest for the 200 regional seats, but only political parties can contest for the 200 compensatory seats. The amended Electoral Act therefore retains the two-tier system while providing an opportunity for independent candidates to contest elections for the National Assembly as required by New Nation 2. Whereas previously, one ballot determined the allocation of regional and compensatory seats in the National Assembly, voters will now receive two ballots, one to vote for a regional seat and one for a compensatory seat. The 200 seats in the National Assembly are allocated to 9 regions, which coincide with the provincial boundaries. The Electoral Commission determines the number of seats allocated to each region based on the number of registered voters in each region. A voter will receive a ballot paper specific to their region, which contains both independent candidates and political parties. That will be the regional ballot. A voter can vote for either a political party or an independent candidate on the regional ballot. All votes cast in a region will first be used to determine a provisional allocation of that region's regional seats to both independent candidates and political parties. If an independent candidate meets the relevant quota for one seat, they will be elected to the National Assembly. Even if an independent candidate gets sufficient votes to be provisionally awarded 2 or more seats, the candidate is only limited to 1 seat. This is because, unlike a political party, which has many candidates and may get many seats, that is not possible for an independent candidate, as they are contesting the elections in their individual capacities and are not affiliated to any party. Similarly, if an independent candidate contests for more than one region and wins seats in more than one region, they forfeit the additional seats in the other regions. The minister submits that that is the inevitable consequence of the choice made by a citizen to contest elections as an individual instead of doing so through a political party. Then there are the 200 compensatory seats. The voter in a region gets a second ballot paper listing only the contesting political parties. The compensatory ballot does not elect compensatory representatives directly. This quota takes into account all 400 seats in the National Assembly minus the seats allocated to independent candidates and is based on the total number of votes cast for the political parties in both the regional and compensatory ballots. The stated purpose of the compensatory seats is to correct the disproportionality in representation in the results of the election. Therefore, the new position after the passing of the Electoral Amendment Act is that 200 regional seats are filled by independent candidates and candidates from political parties, and the 200 compensatory seats are filled by candidates from the list of political parties only. Independent candidates are thus excluded from contesting for the compensatory seats. In its submissions to this court, the applicant did not object to the principle that independent candidates can only compete for regional seats, whereas political parties can compete for both regional and compensatory seats. The applicant takes issue with the fact that independent candidates can only compete for 200 regional seats and argues that independent candidate will, as a result, be required to earn more votes in order to secure a single seat in the National Assembly compared to political parties. The contention that candidates for regional seats will have to earn more votes than candidates for compensatory seats is based on an analysis by Mr. Michael Atkins in his report, whose expertise lies in the fields of mathematics and computer science. Briefly, Mr. Atkins' thesis is that based on data from the 2014 and 2019 elections, independent candidates will require more votes than political parties to win a seat in the upcoming national elections. The applicant therefore seeks an order in terms of which the compensatory seats would be reduced from 200 to 50. As a result, those competing in the regional tier will contest for 350 seats instead of 200 seats. This will result in a 350-50 split as opposed to the 200-200 split contemplated in the Electoral Amendment Act. In a unanimous judgment penned by myself with Zondo CJ, Mayati CJ, Olapen J, Matopo J, Rogers J, Skippers AJ, Theron J, and Fansale AJ concurring, this court held that the circumstances of this case are exceptional and that the application raises legal issues of fundamental importance relating to the fairness of the 2024 elections, and that the time is of essence since the 2024 elections are imminent. Therefore, direct access must be granted. Regarding the merits of the application, it is tried that in order to pass constitutional muster, the exercise of public power by the executive and other public functionaries must at the very least comply with a threshold of rationality. As long as the purpose sought is within the authority of the functionary, as long as the functionary's decision is rationally connected to that purpose, a court cannot interfere with the decision simply because it disagrees with it. The applicant admits that the 220 split is irrational and inconsistent with the rule of law, and therefore contravenes Section 1C of the Constitution. It also argues that the irrationality stems from the quota for regional seats being much lower than the quota for compensatory seats. The respondents submit that the Electoral Amendment Act is rational in that the two different methods used by the Electoral Amendment Act to fill regional and compensatory seats, legitimately differentiate between independent candidates and political parties for the express purpose of achieving proportional representation and avoiding the risk of overhang. The rationality of the 200-200 split, I beg your pardon, therefore hinges on whether A, it results in proportional representation in general, and B, avoids the risk of overhang. Section 46(1)(d) of the Constitution requires Parliament to design an electoral system that results in general in proportional representation. There are 400 seats available for contestation in the National Assembly, which in terms of the impugned schedule are divided in half, 200 regional seats and 200 compensatory seats. The stated purpose of the 200 compensatory seats, according to Parliament, is to correct this disproportionality in representation in the results of the election. Parliament contends that proportional representation systems are in general subject to distortions with the introduction of independent candidates. This is so because irrespective of how many votes an independent candidate receives, they are restricted to a maximum of 1 seat. According to Parliament and the Minister, the only way to include independent candidates in a two-tier system while retaining proportional representation is to allow them to retain the seats they win and obtain proportionality by allocating the remaining seats to the parties that gain representation. The applicants accept that the 200-200 split results in general in proportional representation. This is also accepted in the Acton's report filed in support of the applicant's case. The respondents accept that a 350-50 split as proposed would also achieve proportionality in general. The applicant also acknowledges that reserving compensatory seats for political parties is necessary to achieve proportionality because the formulas for regional seats have the potential to distort proportionality, and this potential has increased because independent candidates can now contest for regional seats but can only hold 1 seat. Properly construed, the dispute between the parties is therefore not whether it is irrational for Parliament to distinguish between regional and compensatory seats in the National Assembly. Rather, the dispute concerns the number of compensatory seats that ought to be reserved for political parties, with the applicant proposing a 350-50 split on the basis that the 200-200 split debases the value of votes for regional seats. Even if the 350 split proposed by the applicant might arguably be fairer and achieve proportionality, Sections 46(1) and 105(1) of the Constitution expressly leaves the choice of electoral system in Parliament's hands. Wide latitude is given to Parliament to consider the manner in which to conduct the electoral system, at least on the requirement of achieving proportionality. The 200-200 split chosen by Parliament passes constitutional muster. The second stated objective of the 200-200 split by Parliament is that it avoids the risk of overhang. The Electoral Commission explains that overhang is when more seats are required to be allocated to restore proportionality as between represented parties after the allocation of regional or constituency votes than are available in the legislature. The applicant contends that the 350-50 split will bring the quota for a regional seat closer to the quota for a compensatory seat without posing a significant risk of overhang or disturbing the proportional representation of political parties. To verify this proposition, the applicant relies on the Atkins report. Mr. Atkins ran a Monte Carlo simulation of elections in terms of the Electoral Amendment Act based on the 2014 and 2019 election results. According to the Atkins report, the 350-50 split gives rise to a foreseeable risk of overhang of up to 15% per election based on the 2040 election data, limited to 1 seat. The applicant argues that while foreseeable, the risk under the 350-50 split is remote and limited to 1 seat. On the 200-200 split, however, there is virtually no risk of overhang, with the only recorded risk found in the Atkins report being at 0.03% at 6% support for independent candidates in respect of 1 seat based on the 2014 election data. Considering the above, on the 200-200 split, there is virtually no risk of overhang. As a result, Parliament's second stated objective of the 200-200 split to avoid the risk of overhang is achieved. The Electoral Commission explained that there is no mechanism under the current Electoral Act to correct the problem should overhang occur. The applicant has also not presented any viable solution to combat the risk of overhang or remedy should it occur. Furthermore, overhang poses the risk that the Electoral Commission would not be able to declare the election should the risk materialize. Even if the risk is as remote as proffered by the applicant, the consequences are severe as explained by the Electoral Commission. Consequently, the foreseeability of overhang under the 350-50 split as proposed by the applicant is potentially destructive to the applicant's case. During the hearing, the applicant submitted that the method utilized at the municipal level to prevent overhang offers a potential solution to the risk of overhang in the 350-50 split. This submission was made for the first time during the hearing. It is well established that parties in motion proceedings should make out their case in their founding or answering affidavits and not in their heads of argument or in the course of the hearing. The exception to this position was articulated by this court in My Vote Counts, NPC, versus Speaker of the National Assembly, where Kampepe J held a point that has not been raised in the affidavits may only be argued or determined by a court if it is legal in nature, foreshadowed in the pleaded case, and does not cause prejudice to the other party. In the present case, this exception does not apply. The proposed solution to the risk of overhang, which the applicant proffered in the hearing, is not legal in nature, nor was it foreshadowed in the applicant's pleaded case. While no weight is attached to the applicant's proposed solution to the risk of overhang, it must be stressed that although the 200-200 split is rational in that it avoids the risk of overhang and ensures proportional representation, this should not be interpreted as an indication that overhang will always be an insurmountable challenge. The risk of overhang arises because, like the Electoral Act, the Electoral Amendment Act prescribes that the full 400 seats of the National Assembly must be available for contestation. This is the maximum number of seats that the Constitution prescribes. Should the number of seats available for contestation in Parliament be reduced to a number above 350 but below 400, it may be possible to allocate overhang seats and increase the number of seats in the National Assembly by the number of overhang seats up to 400 until the next election. This is how the New Zealand Parliament addresses the risk of overhang. Secondly, unlike the Local Government Municipal Structures Act, the Electoral Amendment Act does not provide a formula to address overhang should it arise. I recognize that the absence of a formula to address overhang in the Electoral Amendment Act may well be as a result of the fact that there is no risk of overhang on the 200-200 split. I refer to the Municipal Structures Act to illustrate that the risk of overhang is not a novel concept in South Africa, and that the legislature has, in the context of local government elections, provided a mechanism to deal with it should it arise. In the result, on the facts and submissions, the 200-200 split passes the rationality test as it achieves proportional representation and avoids the risk of overhang. We thereafter consider the issue whether the electoral scheme has infringed any fundamental rights in the Constitution. The applicant contends that the 200-200 split is unconstitutional as it violates sections 1C, 32A, 9.1, 19.2, 19.3, and 46.1D of the Constitution. In view of the conclusion that the split is rational and achieves proportional representation in general, the applicant's challenge that the provisions of sections 1C and 46.1D are infringed falls to be dismissed. The applicant further argues that the 200-200 split violates section 32A of the Constitution in that a vote for an independent candidate carries less weight than a vote for a political party. In reaching this conclusion, the applicant's report rests on the assumption that voters who vote for a political party in the regional ballot will vote for the same party in the compensatory ballot. The applicant also submits that the split violates section 9.1 of the Constitution in that it arbitrarily differentiates between independent candidates and political parties. In New National Party versus Government of the Republic of South Africa, the applicant in that case argued that the requirement of a bar-coded identity document excluded eligible voters who did not have a bar-coded identity documents, and that this breached section 9.1 and 9.2 of the Constitution. In considering this argument, Jacob J. said the following: "It is clear from what has been said in this judgment that although the documentary requirements in issue may be said to differentiate between different categories of people, there is a rational connection between the measure and the legitimate governmental purpose of facilitating the effective exercise of the important right to vote. No discrimination or unfairness has been established." In Democratic Party versus the Minister of Home Affairs, this court had a similar application as in New National Party. Goldstone J. for the majority held that in the absence of evidence showing that the impugned provisions have had the effect of infringing on the right to equality as suggested by the Democratic Party, it cannot be found that the provisions on that account were unconstitutional. This court therefore rejected the Section 9 equality challenge in Democratic Party and in New National Party on the basis that A, there was a rational connection between the measure adopted by Parliament and the legitimate governmental purpose, and B, the applicant failed to provide evidence to support the alleged inequity. In United Democratic Movement versus President of the Republic of South Africa, this court held that the fact that a particular system operates to the disadvantage of particular parties does not mean that it is unconstitutional. Similarly, in Democratic Party, this court held that it must be accepted that there are very few laws of general application that will not directly or indirectly have the potential to affect different categories of people in different ways. From this court's judgments, it is therefore clear that a law affects different categories of people differently. A law that affects different categories of people differently does not prove a violation of the right to equality as provided in Section 9 of the Constitution. The person alleging the violation should provide evidence to support the alleged violation. The proposition that a vote for an independent candidate carries less weight when compared to a vote for a political party is without merit. Independent candidates and political parties compete for the same quota in regional elections and votes carry the same weight. There is no differentiation in respect of regional seats. The applicant's argument that the Electoral Act as amended devalues a vote for an independent candidate is based on the assumption that a voter that votes for a political party will vote for the same party on both the regional and compensatory ballot, which in turn means that independent candidates need double the votes needed by political parties to gain a seat in the National Assembly. By parity of reasoning, vote splitting beyond a de minimis trivial level by voters who vote for political parties would be fatal to the applicant's rights violation challenge. While the 2024 national elections will be the first elections South Africans will get to vote using 2 ballots for the National Assembly, it is not inconceivable that voters may choose to split their regional and compensatory votes. There is in fact evidence of vote splitting by South African voters in the last provincial and national elections. When one considers the 2019 provincial and national elections in South Africa, there were no cases where the party-specific vote totals for the national and provincial votes corresponded exactly. Further, the Electoral Commission explains that in municipal election where independent candidates stand for political election as ward candidates, most voters that support independent candidates also choose to support a political party on the second ballot. Notwithstanding the aforesaid, I do not think that an electoral law could ever be properly formulated on the basis of an assumption as to how people will vote, as the applicant suggests. An electoral law must always assume a complete freedom for the electorate to vote as they please, including splitting their vote where an opportunity to do so exists. In conclusion, the applicant has not been able to prove that A, the split is arbitrary, and B, a vote for an independent candidate carries less weight. Bearing in mind that the mere difference in effect of the split is not in and of itself evidence of unequal treatment in the manner protected against in the Constitution. Therefore, the applicant has failed to discharge the onus of proving the model articulated by Parliament infringes on the equal protection provisions provided for in sections 3(2)(a) and 9(1) of the Constitution, as alleged. For these reasons, the section 3(2)(a) challenge also fails. The next issue relates to the argument that the 200-200 split violates sections 19(2) and 93 of the Constitution in that it undermines the fairness of the outcome of the elections and that the split violates the right to vote and to stand for public office. The applicant submits that the 200-200 split infringes on the right to equal benefit of the law and the right to stand for public office, as votes for independent candidates weigh less than votes for political parties and makes it more difficult for an independent candidate to be elected. In ex parte Minister of Safety and Security, in Re S. versus Walters, this court set the test for examining whether an enactment violates a right in the Bill of Rights and held that this entails examining A, the content and scope of the relevant protected right, and B, the meaning and effect of the impugned enactment to see whether there is any limitation of A by B. In the present case, the content and scope of the relevant protected right refers to the political rights protected under section 19(2) and 19(3) of the Constitution. This court's jurisprudence shows the importance of political rights in light of our history of political exclusion, and the right to vote and the right to free and fair elections are closely linked. While the right to vote gives content to the right to free and fair elections, the right to free and fair elections has implications for how the right to vote must be exercised. This court in Camp versus Electoral Commission distilled elements fundamental to free and fair elections as protected under Section 19(2) of the Constitution. These elements include: A, persons entitled to vote should be registered to do so, and B, the protection of the right to participate in elections as a candidate and to seek public office. In my view, the elements distilled by this court in Ham are met under the 200-200 split. The Electoral Amendment Act entitles every adult citizen to a vote, and they can, in keeping with this court's ruling in New Nation, to vote for either a political party or an independent candidate. The Electoral Amendment Act also allows citizens to stand for political office and hold office if elected. The contention that a vote for a political party counts double to that of an independent candidate, which, as applicant argues, leads to a limitation of Section 19 rights, is, as I have already demonstrated, without merit. This argument is based on the assumption that voters will not split their vote, an assumption which I have already shown to be unsustainable. The applicant was required to show that the measures adopted by Parliament constitute a limitation of the political rights alleged. For the reason stated, the applicant has failed to discharge these onus, and as such, the 200-200 split passes the second leg of the Walters test. It follows that the Section 19 challenge must also fail. Due to this conclusion, it is not necessary to conduct the justification analysis under Section 36 of the Constitution, as I have concluded that the impugned schedule does not violate any of the fundamental rights alleged by the applicant. To sum up, the applicant has not established that the impugned legislation is irrational, nor that it infringes a provision in the Bill of Rights. Therefore, it has not made out a case to justify the declaration of constitutional invalidity. It follows that the application must be dismissed. Following the principle set by this court in BioWatch Trust versus Registrar Genetic Resources, each party must pay their own costs. In the result, the following order is made. 1, direct access is granted. 2, the application is dismissed. 3, there is no order as to costs. I hand down the judgment.
As the court, please.
Thank you. You may call the next case.
I call the matter of One Movement South Africa NPC and President of the Republic of South Africa in matters for judgment.
May it please the Court Justices, I confirm my appearance on behalf of the applicant.
Thank you.
May it please the court, I appear for the Electoral Commission in this matter as well.
Thank you.
May it please the court, I appear on behalf of the first, second, fourth, and fifth respondent.
Thank you.
Thank you. In this matter, there are 3 judgments. 2 deal with the signature requirement and 2 deal with what has become known as the recalculation challenge. What I will do is provide an overview of the case and the factual and legal issues that underpin it, and then deal briefly with the thrust of the 3 judgments before dealing with the order. I'll proceed. Today, this court hands down its judgment in an application for direct access brought by the One Movement South Africa, OSA, on an urgent basis that was heard by this court on the 29th and 30th of August 2023. The application was brought against the President of the Republic, the Minister of Home Affairs, the Speaker of the National Assembly, the Chairperson of the National Council of Provinces, and the Independent Electoral Commission. In 2020, this court handed down its judgment in New Nation Movement, in which it declared the Electoral Act of 1998 inconsistent with the Constitution and therefore invalid insofar as it did not allow an adult citizen to stand for public offices independently of a political party. This court suspended that declaration of invalidity for 24 months to afford Parliament the opportunity to correct the constitutional defect that this court had identified in that case. In response to the New Nation Movement, Parliament passed the Electoral Amendment Act number 1 of 2023 in February 2023, which made it possible for an adult citizen to stand for public office independently of a political party, provided that such candidate met certain conditions or complied with certain requirements. Apart from asking for direct access and that the matter be dealt with on an urgent basis, OSA mounted 2 constitutional challenges to the Act. The first challenge was directed to the provisions of Section 31(b)(3), which require an independent candidate and a political party, that is, a political party that is not yet represented in the National Assembly or in any provincial legislature, to secure and produce supporting signatures of registered voters in the relevant region amounting to 15% of the quota of the relevant region in the preceding election in order to be allowed to contest an election. For convenience, I shall refer to this as the 15% signature requirement. A quota is the total number of votes that a political party or independent candidate must obtain in an election in order to get 1 seat. The second constitutional challenge mounted by OSA relates to those provisions of the Act which prescribe how the recalculation of allocations of seats is done whenever a seat in the National Assembly or a provincial legislature previously occupied by an independent candidate becomes vacant, either as a result of death or resignation. The relevant provisions are item 11F of the amended Schedule 1A, which relates to a seat in the provincial legislature, item 5I of the amended Schedule 1A, and item 23 of Schedule 1A. OSA's second challenge will be dealt with shortly. It is necessary to deal with the first challenge first. OSA's first constitutional challenge was that the 15% signature requirement constituted a barrier for independent candidates who wished to contest elections. Although this was not spelt out clearly in OSA's papers, it seems that part of its complaint was that the 15% signature requirement was too high and that the requirement should be replaced by a requirement of 1,000 signatures. The regulations under the Electoral Act include provisions that require that a political party should produce 1,000 signatures of registered voters who support it when it seeks to register with the IEC. This is a registration requirement. The 15% signature requirements applies to independent candidates and new political parties when they want to contest elections. OSA contended that the 15% signature requirement detrimentally affects independent candidates' right to dissociate, their right to make political choices, their right to stand for public office, their right to dignity, and the right not to associate with the political party system by running as an independent candidate. The Minister of Home Affairs and Parliament opposed OSA's application to have certain sections of the Act declared constitutionally invalid. They did not oppose the application for direct access and that the matter be dealt with on an urgent basis. The IEC did not oppose OSA's application and filed a notice to abide the decision of this court. It also filed an explanatory affidavit to assist the court. The Minister, Parliament and the IEC set out how, over an extended period, the signature requirement moved from 50% of registered voters in the relevant region to ultimately 15% as decided by Parliament. They explained that the 15% signature requirement applies to both independent candidates and new political parties, but did not apply to political parties which were already represented in the National Assembly or in a provincial legislature. Parliament, the Minister and the IEC explained in their respective affidavits that the purpose of the 15% signature requirement in the Act is to ensure that independent candidates and new political parties which contest elections would be those who have a serious and have a credible prospect of obtaining at least one seat in the elections. OSA did not dispute that this is the purpose of this 15% signature requirement. Parliament, the Minister and the IC also stated that there was a rational connection between this requirement and a legitimate government purpose. Parliament, Minister and the IC made it clear that the 15% is the 15% of the quota of a region or province in a preceding election. In this regard, Parliament had decided to use provinces or regions as constituencies. They also pointed out that Parliament had decided not to use a fixed number of signatures, such as, for example, 1,000, but decided to use a percentage of a quota. In this regard, Parliament had decided upon 15% of a quota of a region. That's so much by way of background. This matter was produced, as I indicated, two judgments in respect of the 15% signature requirement. The first judgment is penned by the Chief Justice. The second judgment is penned by myself. There is also a third judgment to which I made reference to, and that is penned by Thoronje, and that deals with the recalculation challenge. I now proceed to deal with the first judgment. The first judgment holds that OSA made out a case for direct excess and for the matter to be dealt with on an urgent basis. The first judgment therefore grants direct excess. On the 15% signature requirement, the first judgment points out that although OSA contended that this requirement is an unfair barrier, OSA did not substantiate this contention so as to show why it was contending that the requirement is a barrier and why it was contending that the requirement is unfair. The first judgment also refers to the fact that in its founding affidavit, OSA said that its chief complaint was that Section 31B3 required both independent candidates and new political parties to comply with this 15% signature requirement, but that OSA did not substantiate this contention either. On this analysis of OSA's founding affidavit, the Chief Justice reasoned that OSA's real complaint was about the size of the regions or provinces and Parliament's decision to use provinces as constituencies. The first judgment points out that the regions or provinces had vastly different sizes, and as a result, they had different quotas. The first judgment highlights the fact that the bigger a province or region, the higher its quota, and therefore the higher the number representing 50% of the quota of the region. The smaller the province or region or constituency, the lower the quota required to get one seat, and the lower the number representing 15% of the quota. The first judgment says, if the quotas were low and the 15% translated into a number as low as 1,000 or 3,000, OSA would probably not complain. The first judgment points out that OSA does not ask this court to invalidate Parliament's decision to use provinces as constituencies. In his judgment, the Chief Justice highlights the fact that OSA said that its chief complaint was that Section 31B3 of the Act required both independent candidates and new political parties to comply with the same requirement, namely the 15% signature requirement, but did not anywhere in its founding affidavit elaborate on this to substantiate it. In other words, OSA did not say what was wrong with the Act requiring both independent candidates and new political parties to comply with the same signature requirement. The first judgment points out that during the hearing, this had been put to counsel for OSA to enable her to point out the substantiation, but she had not been able to do so. The first judgment also states that although OSA contended that the signature requirement was an unfair barrier for independent candidates wishing to contest the elections, OSA also did not elaborate on this so as to show why it was contending that the requirement was a barrier or if he or she is to stand any chance to get a seat in the elections. The 15% signature requirement advances a candidate's ambitions of winning a seat in the elections. It does not impact it negatively at all. Therefore, it does not Assembly or a provincial legislature, or when vacancies arise either owing to death or resignation. A forfeiture occurs in three scenarios, namely A, if the party has submitted a national or regional list with fewer names of party candidates than the number of seats to be allocated to it, the number of seats for which it has no listed candidates is forfeited. B, if an independent candidate stands to be allocated more than one seat in a region, any excess seats won by the independent candidate are forfeited, since an individual candidate can, by definition, only hold one seat. And then finally, C, if an independent candidate contests the elections in more than one region and wins a seat in more than one region, that candidate will be allocated a seat in the region where he or she received the highest proportion of votes, and any excess seats are forfeited. Where a forfeiture occurs, the initial or provisional allocation of seats is recalculated in the affected regions in accordance with the method prescribed in item 7 subsection 3 to subsection 6 of Schedule 1A, which applies to the National Assembly, and item 12 subsection 3 to 5, which applies to provincial legislatures. When vacancies arise in the National Assembly or in a provincial legislature, either as a result of a death or resignation, such vacancies are dealt with in items 22 to 24 of Schedule 1A. OSA proceeds to say that the next question is, quote, whether the limitation is unjustifiable in terms of Section 36(1) of the Constitution, close quote. OSA then says this question comes down to whether there are less restrictive means to achieve the purpose, which is ultimately a question about threshold. One of the grounds on which OSA attacked the recalculation is that a vote for an independent candidate is not a vote for that individual, but a vote that rejects party politics. OSA criticizes the notion that votes that were cast for an independent candidate can end up being awarded to a political party. The first judgment rejects this criticism as one that has no merit. A voter can vote for an independent candidate in regard to a provincial legislature and for a party in respect of the National Assembly. Just because a voter has voted for an independent candidate does not mean that he or she does not necessarily want party politics. Furthermore, the votes in favor of the independent candidate whose seat is forfeited or vacated is not awarded to a political party. Those votes are removed altogether in the calculation. OSA also criticizes the recalculation method provided for by the Act and says it entails that political parties have a second bite at the cherry. The first judgment points out that this refers to the occasion when the amended quota is applied. The first judgment refers to an explanation given by Mr. Mamabolo, who rejects this criticism and says, amongst other things, that disregarding the votes cast for independent candidates in the event of a forfeiture or vacancies ensures that interplay proportional representation is maintained in the legislature. That should be inter-party proportional representation, sorry. The first judgment points out that, as Mr. Mamabalo explains in his affidavit, votes cast for any independent candidate in an electoral system based on proportional representation inevitably affects inter-party proportional representation in the legislature, as an independent candidate can only hold one seat irrespective of how many votes they win. By disregarding the votes cast for independent candidates who are not eligible to be allocated the seat in the recalculation, that influence on inter-party proportionality is limited. The first judgment found that Parliament, the IEC and the Minister provided explanations in regard to all OSA's criticisms, and as OSA did not file affidavits to challenge or dispute those explanations, they must be accepted. In the result, the first judgment rejected OSA's second constitutional challenge as well. The first judgment points out that the second judgment replaces the 15% signature requirement in circumstances where there is no basis to interfere with Parliament's decision to use a percentage of a quota rather than a fixed number. The first judgment points out that the 1,000 signature requirement decided upon by the second judgment does not help to assess whether an independent candidate has credible prospects of obtaining a single seat in the elections because it is too low, and furthermore, the regions are different in size. The first judgment states its conclusion is in line with the decisions of this court in New National Party, Democratic Party, Ruchte, and Affordable Medicines. Finally, the first judgment points out that the second judgment relies on foreign legislation applicable to certain countries without affording Parliament, the Minister, and the IEC the opportunity to address the court on those, or to place before the court other foreign pieces of legislation which may have portrayed a different picture. In the result, the first judgment would have dismissed OSA's application, but would not have made any order as to cost. With regard to that part of the first judgment that relates to direct excess, the following justices concurred in the first judgment: Deputy Chief Justice Maya, Justice Mtantla, Justice Matopo, Justice Kolopin, that's me, Justice Rogers, Acting Justice Skippers, Acting Justice Van Zyl, and Justice Theron. With regard to the part of the first judgment that relates to the signature requirement, Matopo J, Skippers AJ, and Van Zyl AJ concurred in the first judgment. With regard to the recalculation point, or OSA's second constitutional challenge, the Deputy Chief Justice, myself, Mtantla J, Matopo J, Skippers AJ, Van Zyl AJ concur in the first judgment. That concludes the discussion on the first judgment. The second judgment, penned by myself, finds that a proper case has been advanced in support of a declaration of unconstitutionality of Section 31B3 of the Act. The second judgment makes two central findings. A, the impugned provision limits the rights in Section 19 to stand for public office and other associated rights. And B, the state respondents have not shown that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. It agrees with the conclusion of the first judgment on both direct excess and the applicant's recalculation challenge. The second judgment recognizes that elections are not just a matter of arithmetic, nor are they exclusively about winners and losers. They serve an intrinsic value that goes to the heart of democracy: the ability to exchange and debate ideas that shape the society we live in and inform the choices we make. The primary point of disagreement with the first judgment is the application of the standard set by New National Party. Contrary to the first judgment's analysis, the second judgment concludes that the New National Party standard exists in a carefully limited and delineated space. It applies when the government takes positive steps to facilitate or give effect to a right, but not when such action goes beyond those objectives. Further, it has subsequently been applied and clarified in non-election cases, in particular this court's judgments in Moloto, Gabas, and Mulungwana. Those cases indicate that the regulation of the exercise of a right will amount to a limitation when it goes beyond regulating and has a limiting and deterring effect. The second judgment also holds that it is not the case that any law that purports to regulate the exercise of a right is permanently shielded from constitutional scrutiny as possibly constituting a limitation of that right. Turning then to whether the 15% signature requirement in this matter passes constitutional muster, the second judgment follows the well-established two-stage approach to determine whether there's been an unjustified infringement of a right. At the first stage, in analyzing the content and scope of sections 18.1, 19.1, and 19.3 of the Constitution, the second judgment emphasizes that the inclusion of the right to freedom of association, freedom to make political choices, and the right to stand for public office hold significant symbolic value given our history of exclusion and form the foundation of an inclusive and encompassing political system. Their inclusion, both individually and collectively, is crucial for the functioning of our constitutional democracy. Further, the interrelatedness of these rights is indicative of their wide breadth and the need to interpret them generously. In analyzing the meaning and effect of the signature requirement and whether it constitutes a limitation of the content and scope of these rights, the second judgment finds that the signature requirement goes beyond mere regulation and has a limiting purpose to prevent frivolous contestation. At 15% of the regional quota, the signature requirement would require between 10,000 and close to 14,000 signatures for contestation and would constitute a barrier to the exercise of the rights in question. It would place a burden on independent candidates seeking to contest elections who would require immense time, resources, and energy to invest in order to meet the 15% signature requirement. This is different to the regulatory framework that requires voters' names and details to be captured on a voter's roll and a barcoded identity document to identify the voters on election day, which gives effect to the right to vote. In such an instance, there is an inextricable and necessary link between those positive steps that the government takes and the realization of the right to vote. Those requirements are formal in nature and hardly burdensome. They are clearly distinguishable from a threshold signature requirement. As such, the second judgment concludes that the signature requirement constitutes a limitation of the applicant's right to freedom of association, freedom to make political choices, and to stand for and hold public office if elected. On the justification analysis, the second judgment finds that the limitation is not justifiable. It reaches this conclusion by applying Section 36 of the Constitution. It finds that the purpose of the limitation is of low importance, where a contestation requirement has never existed in any previous elections, despite increasing trends that demonstrated greater contestation coupled with poorer successful outcomes. These trends never prompted the need for a signature requirement for contestation. The second judgment records that political parties, according to Parliament, make sensible political and economic decisions around whether and when to contest an election. And so there was historically no need for a signature requirement until New Nation movement. This begs the question, why should the same not be expected of independent candidates, and why a signature requirement now when one was never needed before? The nature and extent of the limitation is arbitrary, where Parliament in its deliberations consistently relied on the wrong quota of 44,000 when calculating 15% of the regional quota, as opposed to the correct quota which averaged 83,500. This fundamental flaw in its processes materially affects the outcome, rendering it arbitrary. Further, the signature requirement is extensive in comparison to signature requirements in other foreign jurisdictions. The second judgment finds that there was a limited relation between the limitation and the purpose, where Parliament consistently relied on the wrong quota, while the previous 1,000 signature requirement constituted less restrictive means to achieve the same purpose. Accordingly, the second judgment orders a declaration of constitutional invalidity. It finds that there would not be sufficient time to refer the matter for Parliament to address the constitutional invalidity before the next election. In these circumstances, practical considerations warrant a remedy in order to address the consequences of the order of invalidity. The second judgment accordingly orders as an interim remedy a striking out in the impugned provision of the 15% quota, and in its place a reading in of 1,000 signatures. It does so on the basis that while there's never been a contestation requirement in place, 1,000 signatures represents at the very least a de facto contestation requirement. The consideration of any other requirement would be an exercise in speculation, which is best avoided. The order is suspended for a period of 24 months for Parliament to cure the defects. In effect, and during the period of suspension, the second judgment finds that a limited striking out of the 15% requirement should be combined with an interim reading in of 1,000 signatures requirement, which prior to the amendment, as I've indicated, served as a de facto consideration requirement. Finally, in concluding, the second judgment observes that New Nation has led to a historic moment in the relatively short journey of our young constitutional democracy. For the first time, independent candidates will stand for seats in the national and provincial legislature. Parliament meets this historic moment with the first of its kind signature requirement for independent candidates. We must be cautious and guard against such a requirement becoming a barrier to contestation. In effect, the signature requirement, if left undisturbed, may render somewhat hollow the enormous promise that New Nation movement heralded in unlocking and giving effect to Section 19 of the Constitution fully and properly. Deputy Chief Justice Meyer, Justice Mtlantla, Justice Rogers, and Justice Theron all concur in the second judgment, except that both Justice Rogers and Justice Theron do not concur with the conclusion reached in the second judgment on the recalculation challenge. I now proceed to deal briefly with the third judgment penned by Justice Theron. The third judgment concurs in the order made in the second judgment insofar as it relates to the signature requirement and cost. However, the third judgment holds that the recalculation method introduced by the Electoral Amendment Act raises a serious constitutional concern. The result of the recalculation is that votes cast for large political parties count more than votes for small political parties or independent candidates. Third judgment finds that this favorable treatment of large political parties constitutes a prima facie limitation of the rights of voters, independent candidates, and small political parties under Section 19 of the Constitution. Further, the third judgment emphasizes the failure of the respondents to justify the limitation. However, the third judgment concludes that it would not be in the interest of justice to decide this challenge due to the matter not being sufficiently explored. And so in the result, and by way of summary, A, on the signature requirement, the majority upholds the challenge of constitutional invalidity and grants interim relief, and B, on the recalculation challenge, the majority dismisses the challenge. The following order is made. 1, the applicant is granted direct access to this court. 2, the recalculation relief sought in prayers 4, 6.2, and 6.3 of the applicant's notice of motion is refused. 3, Section 31B3A 1 and 2 of the Electoral Act 73 of 1998, as inserted by the Electoral Amendment Act number 1 of 2023, is declared invalid and inconsistent with the Constitution to the extent that it unjustifiably limits the rights to freedom of association, freedom to make political choices, and to stand for public office. 4, the declaration of invalidity referred to in paragraph 3 is suspended for 24 months from the date of this order to afford Parliament an opportunity to remedy the constitutional defects, giving rise to the constitutional invalidity. 5, from the date of the order of this court and during the period of suspension, Section 31B3A 1 and 2 of the Electoral Act will read as follows. the underlined words in the order being read into the section with the words in strikeout text being severed. Quote 3. The following must be attached to a nomination when it is submitted. A completed prescribed form confirming that the independent candidate has submitted in the prescribed manner the names, identity numbers, and signatures of voters whose names appear 1. In the case of an election of the National Assembly in respect of regional seats on the national segment of the voters' roll, and who support his or her candidature, totaling 1,000 signatures for each region in which the candidate intends to contest an election. Roman 2, in the case of an election of a provincial legislature on the segment of the voters' roll for the province, and who support his or her candidature, totaling 1,000 signatures, provided that an independent candidate who was elected to either the National Assembly or a provincial legislature as an independent candidate in the preceding election shall be exempt from this requirement. 6. In the event that Parliament does not remedy the constitutional deficiency in Section 31B 3A 1 and 2 within the period provided for in paragraph 4 of this order, or any extended period granted by this court, then Section 31B3A 1 and 2 will be deemed to read as set out in paragraph 5 above. 7. The second, fourth, and fifth respondents, jointly and severally, are to pay 50% of the applicant's costs, which costs shall include the cost of 2 counsel. The applicant is not entitled to recover any costs associated with the report of Mr. Atkins. That concludes the order and the judgment. The judgment is handed down.
As the court pleases.
That concludes our business today. Court adjourns.